Yes, justice is important. Some even consider that the justice is as important as the right to food. That's why the African states have established impartial and independent judicial systems within their countries. And this is also why the African states have, at the international level, established an African Court on Human and People's Rights at the level of the African continent, along the lines of the European Court of Human Rights and the Inter-American Court of Human Rights. Justice and international justice is actually very important for peace and stability as well as for development in the African countries. In 1998, the African state therefore decided to create an African Court on Human and People's Rights, which is now based in Arusha, Tanzania. This court is composed of 11 judges coming from each 5 parts of the African continent. And this court has two-fold jurisdiction. This court can deal with any violation of human rights on the African continent on the basis of applications, complaints received at the registry of the court, and also by delivering advisory opinions. So this is, in a nutshell, what the court is and what the court is doing. The court has so far received a certain numbers of applications and have dealt with accordingly. South Africa, for example, is party to the protocol, and that's why there's a South African judge sitting together. It's my colleague, Judge Bernard Goupé. The court is a very important tool, actually, for the peace and security on the continent, on the African continent. And that's why we came here, my colleague, the president of the court and myself, to advocate, to sensitize African states here at the summit of head of states in order to ask them to continue to support the court as far as finance is concerned, budget of the court, and as far as human resources is concerned, recruitment of staff. This is one of the reasons we came here. We also came here to ask the African states, which have not done so, to ratify the protocol establishing the court. So far, out of 54 states, members of the African Union, only 26 are parties to the protocol. And out of those 26, only 5 of them have accepted the jurisdiction of our court to deal with individual applications or complaints emanating from individuals or non-governmental organizations. Only 5 states. So we are trying to sensitize the states in order to file this application. So, to tell you the truth, states have been rather sensitive to our plea, and some of them are willing to do it in the future, to ratify the protocol or to file the special declaration. And the head of states has also decided to continue its support to the activities of the African Charter by giving us the financial means to sustain our activities. So this is a very strong signal which has been sent to us by the African states, which are very keen, which are very keen on the issues of peace and security, and they have understood that justice is really a pillar of stability and one of the main components of peace and development on the African continent. So one of the challenges facing the court is actually this ratification of the protocol and the filing of the special declaration, allowing individuals to come to the court and to file complaints against states parties which have violated the Charter. And the aim is to reach actually the popularity of the European Court of Human Rights, for example, which has now a very big workload, whereas the African Court, has not much to do for the time being. We have been seized of 23 applications and we have already decided 13 cases. So this is mainly what the court is doing, and mainly the challenges that the court is facing for the next few years.